Thank you, Mr. Vice President. Mr. Vice President, before I begin, I believe that Senator Thompson-Ayi has a question to pose. Senator, if you wish to do that now.
I wanted to ask you, through you, Mr. President, acting, whether the Attorney General, in crafting this law, which is, of course, as he said, that there had been previous amendments, whether in crafting this law, he actually looked at the Canadian provision to see how they have dealt with the changes in their bankruptcy laws and so on. I'm also asking whether, in fact, he looked to see how Barbados, over the last few years have dealt with their bankruptcy laws, and in fact, they've put in the Office of Supervisor of Insolvency. Because the concerns raised here this morning are valid concerns. So that, there's always time to do it over, but hardly time to do it right. And perhaps what we can do, if I may so
thank you, Honourable Senator.
Is that we tarry a while.
Thank you.
And look at what has happened in Barbados, so that the concerns can be addressed and we can get it right, so we don't have to come back and amend and amend.
Thank you so much.
Thank you.
Thank you, Mr. Vice President. Mr. Vice President, I'm very pleased to answer the submissions made by honourable senators opposite. In immediate answer to Senator Thompson-Ayi, I can say yes, we have looked at the recent amendments in a number of Commonwealth jurisdictions to treat with bankruptcy and insolvency. We have looked at Barbados and we have looked at Canada. And Mr. Vice President, I can say the bankruptcy and insolvency legislation which has featured in this debate is a collateral issue that we're treating with today. This law is not solely about bankruptcy and insolvency. In putting in the official receiver, we are saying that the official receiver definition is to apply in the context of the Companies Act. In the Companies Act, it is not mandatory, as Senator Mark presents the argument, that the official receiver is automatically included. My colleague Senator Mitchell stood in a very lucid point of order to say that Senator Mark was contradicting his own argument. And let me demonstrate what I mean by what I just said, and let me expand upon what Senator Mitchell put to the table. You see, Mr. Vice President, in the Companies Act, Senator Mark went quite remarkably to Section 370 of the Act. 370 says, subject to the provisions of this section, the court may appoint a liquidator provisionally at any time after the presentation of a winding-up petition, and either the official receiver or any other person may be appointed. It is not mandatory. Senator Mark made a very bold-faced submission to say that if you look to the Companies Act, he counted it, he said 288 references to official receiver automatically means that you have to read that as Chief State Solicitor, implying in his submission that the court does not have an election in its inherent and jurisdiction and in exercise of its statutory considerations to appoint someone else. And let me make the example clear. If we look to the Companies Act, which we're amending, and we look to Section 367, which follows Section 366, which we are deleting, we're repealing it. Section 366 says the official receiver is the official receiver attached to the court for bankruptcy purposes and includes an assistant official receiver. Let me deal with the issue before I jump off of the repeal here of this so-called allegation of ministerial control and conflict of interest and public officers, etc. Senator Mark referred to the fact that the Chief State Solicitor falls under the Office of the Attorney General. Yes, that has been so since independence, since 1976 in republicanism, and even before that, Mr. Vice President, in our colonial construct, albeit that the Attorney General was a different type of office holder then, the Chief State Solicitor has acted that way. Secondly, Mr. Vice President, in what I consider to be an unworthy attack against the integrity of the office of Chief State Solicitor, and I say that quite sincerely, I remind that Senator Mark's argument fails in saying that there's a conflict of interest, because if that's so, why is the Chief State Solicitor in law the person appointed as the public trustee? The Public Trustees Ordinance, Chapter 8, Number 4, 1950 editions of the law of Trinidad and Tobago, sets the Chief State Solicitor as the public trustee. If Senator Mark's argument is correct, then under the 5 years and 3 months that his government under Mrs. Prasad Bisesa led this country, they should have abolished the Chief State Solicitors acting in law as the public trustee. Senator Mark omits that the Chief State Solicitor sits as one of 5 public officers on the Central Tenders Board. If it was such a conflict of interest, this office holder should have been abolished by the UNC government in the 5 years and 3 months that they were in office. Senator Mark conveniently omits an archaic piece of law. That is the 1939 Trading with the Enemy Act, where under Section 10(1), the Chief State Solicitor is appointed to preserve enemy property, again a public officer. But let's get to the Companies Act, which we are amending. Let's get to Section 366. We're proposing to remove that definition. I remind that the Chief State Solicitor is an attorney at law and therefore an officer of court, like any other officer of the court. I remind that the Chief State Solicitor is subject to the constitutional reflection of Section 136 of the Constitution, where the tenure and salary and office of the public officer, Chief State Solicitor, is reflected on as a senior legal officer, a chief legal officer. I remind Mr. Vice President that in Section 367, this is the language: where the court has made a winding up order or appointed a provisional liquidator, there shall, unless the court otherwise orders, be made out and submitted to the official receiver. That is a discretion in the court, Mr. Vice President. Anybody that has practiced in winding up, in insolvency, in liquidation, as I have for a number of years, will tell you that the court has the ultimate discretion to entertain any objections, Mr. Vice President. Mr. Vice President, when we look to let's go to the second schedule of the Companies Act, which is the winding up rules. When we get to the second schedule, the company's winding up rules, let me, for example, point out to you, in answer to Senator Mark's argument and Senator Lutchmedia's argument, let me point out, if you look to the appointment of a provisional liquidator in Rule 24, and you note that after the presentation of a petition and upon an application of a creditor or contributor, etc., a company may go through winding up. Listen to subsection 4. Where any person other than the official receiver has been appointed provisional liquidator and the official receiver has taken any steps, etc., the provisional liquidator shall pay official receiver. Again, it is a reflection of the fact that it is in the court's discretion to appoint anyone in the capacity of liquidator, in the capacity other than official receiver. If there's an objection to the official receiver being the Chief State Solicitor, that application can be made. But let me tell you how confusing my colleagues opposite on the opposition bench's arguments are. We heard reference to the Bankruptcy and Insolvency Act. Mr. Vice President, what I find remarkable is that my colleagues opposite will not read the law. And if you go to the Bankruptcy and Insolvency Act and you go to Section 175, Mr. Vice President, and we looked at that particular provision, let's see what that actually says. Section 175 falls under Part 9 of the administrative, and it's entitled Administrative Officials. Section 175 creates the appointment of supervisor. And here's what it says. For the purposes of this act, there shall be a supervisor of insolvency who shall be responsible to the minister. Let me repeat that. The supervisor of insolvency shall be responsible to the minister for the general administration of this act, and whose office shall be a public office. Stick a pin. We heard Senator Lutchmedia say, let's go deeper into reflection and let's get the supervisor of insolvency in. What is the difference between a public officer under Section 175 reporting to a minister and the Chief State Solicitor, who is a public officer reflected in the Constitution, reporting to the Attorney General? When the Chief State Solicitor, as official receiver, has the obligation in law to report to the court. The court has the supervisory jurisdiction on liquidation, on winding up, on insolvency. It is not the Attorney General who is there willy-nilly pulling the strings of the official receiver, because in the due process environment of winding up, liquidation, insolvency, the creditors are before the court, and the creditors are given an opportunity to be heard. So for Senator Mark to say it is draconian and this is the end of the world and there's a conspiracy afoot, Mr. Vice President, is the Honourable Senator casting aspersions on the entire judiciary apart from the Chief State Solicitor's Department? Is the Honourable Senator forgetting that the supervisory and inherent jurisdiction of the court operates at all times without fetter under the separation of powers principle? Mr. Vice President, in Senator Lutchmedia's recommendation that we use the Supervisor of Insolvency, the Supervisor of Insolvency shall supervise the administration of all estates and matters to which the Bankruptcy and Insolvency Act applies. That's Section 175(2). 175(3), the supervisor shall, without limiting the authority, receive applications for licenses to act as trustees under the Act. Trustees are appointed to receive property that goes into winding up, etc. Where not otherwise provided, require the deposit of guarantee of bonds, etc. From time to time, make or cause to be made such inspection or investigation of estates. How do my friends opposite seriously and in sober terms say to the world, use the Supervisor of Insolvency in the context of winding up, when the Supervisor of Insolvency is an administrative official with an entirely different portfolio? I mean, for heaven's sake, Mr. Vice President, do they even bother to consider the circumstances and the locus and the roles and responsibilities of the officers? Is the question now afoot? Yes, please.
I heard mentioned here that the court could appoint the official, the Chief State Solicitor as a liquidator. That's what you said, isn't it?
I was referring to the provisions of provisional liquidation in the law.
Because you seem like, the Attorney General seems like Senator Mark to make no differentiation between a receiver and a liquidator.
Thank you, Senator.
And that is so important.
Yeah. Senator, I'm sorry, I have such little time in winding up, and unfortunately you elected not to speak. So forgive me for re-interrupting. I'm not conflating or confusing. I was drawing reference to the liberty of the court in the statute that we're dealing with, the Companies Act, the Insolvency and Bankruptcy Proceedings Act, and in the winding up rules in the second schedule to the Companies Act, to have the discretion to appoint the official receiver or someone else in multiple capacities, be it in liquidation, be it in receipt, be it in winding up. Obviously, there are different rules that we're speaking about, but we are not to conflate Senator Mark's argument, which is that you have to read this as a mandatory, you must appoint the Chief State Solicitor as receiver. And therefore, Mr. Vice President, I am saying that the mischiefs raised by my colleagues opposite are to be met by the due process of the court, are to be met by the safeguards and balances of the legislation which we are amending. It is to be met by the fact that there's an overriding discretion. And I was dealing with Senator Lutchmedia's recommendation that we look at the Supervisor of Insolvency as opposed to the Chief State Solicitor, after Senator Lutchmedia raised the position of the conflict of interest. And I answered that by saying, well, where is the conflict of interest argument to be drawn in the line, in the sand, if the official receiver is a public officer and the the supervisor of insolvency is a public officer equally, if the supervisor reports to a minister, and if the chief state solicitor operates under the attorney general, but has the distinction of reporting to the court and being subject to the supervision of filed proceedings, subject to objection by creditors or other persons before the court in whatever capacity. Mr. Vice President, permit me to say, in answer to Senator Mark's conspiracy theory about replacement of officers, etc., and liquidators, there is no such position. We're dealing with the law in general purport. I reject the argument that this law is ad hominem in any fashion, Mr. Vice President. I am saying for the record that this law is much more than, the bill that we have before us is much more than insolvency and liquidation. It is equally in the context of Section 366, of Section 246, etc. We are dealing with, Mr. Vice President, we're dealing with the position of assets that are left over on striking out. We're dealing with the law of general application because the role of the official receiver is much more than just insolvency. There are multiple factions and issues inside of that. Mr. Vice President, as to the allegation that the law is sloppy drafting in 2019, please permit me to just reject that out of hand. Let me explain the construct of the argument by my friends opposite. In 2019, we came with a very narrow sectional definition to put, for the purposes of dissolution of companies, the official receiver in. This lacuna in the law came about in 2014 when the 2007 Bankruptcy and Insolvency Act, Chapter 970, was proclaimed. And anytime you are engaged in a proclamation, you have an obligation to check the impact of proclamation. But not surprising, Mr. Vice President. That's how Section 34 was born in the Preliminary Inquiries Administration of Justice realm, where you don't check, perhaps on purpose, the impact of laws when they're proclaimed. But in 2014, if you think, dear Honourable Senator Mark, through you, Mr. Vice President, that it was sloppy, well then turn to your own government in 2014 for not having checked the law. And Mr. Vice President, I have on a number of occasions explained the government's position that we are here as a parliament to continuously make law for the peace, order, and good governance of our country. And Mr. Vice President, I've already given the heads up that there are further amendments to the Companies Act, one in the Global Forum EU context, and another in the ease of doing business and elimination of paper and going to online filings, and therefore the law is continuously under review. Mr. Vice President, may I end my contribution by saying it is always a pleasure to be before the honourable members of this House to provide explanation as it is properly required. I will say that the laws are under constant review. The general provisions of the bankruptcy and insolvency provisions, being the Canadian model, are very opposite to our interests. There's no conflict there, but we ought not to conflate the rules and functions of administrative officers, as for instance under that law, with what we're dealing with today. In final submission on the conflict of interest point, there is none. There is an insulation by the JLSC to public officers, as we're well aware. And Mr. Vice President, I believe that that is the summation of answer to issues posed by my friends opposite, and therefore I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the Companies Act, Chapter 8101, to make provisions for the role of the Chief State Solicitor as the official receiver be read a second time. Those in favour say aye.
Aye.
Those against say no. I believe the ayes have it.
A bill entitled An Act to Amend the Companies Act, Chapter 8101, to make provision for the role of the Chief State Solicitor as the official receiver.
Attorney General.
Mr. Vice President, in accordance with Standing Order 66-1, I beg to move that the Companies Amendment Bill 2022 be committed to a Committee of the Whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that the Companies Amendment Bill 2022 be committed to a Committee of the Whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. I believe the ayes have it. The Senate shall now go into Committee of the Whole to consider the bill clause by clause. Clauses 1 to 5. The question is that clause 1 to 5 stand part of the bill.